940 words within the 5% target range. Here's the finished script. There is a fund called the Congressional Accountability Act Settlement Fund. No law you've read explains it in plain English, and it has quietly paid taxpayers money to settle claims against members of Congress since 1995, with no public record of who got paid or why. Here is what it actually is, stripped of the legal language. When someone accuses a member of Congress or a congressional office of harassment, discrimination, or a workplace violation, the case doesn't go to a normal court the way a lawsuit against your employer would. It goes through a private process inside the Capitol, run by Congress's own compliance office. If a settlement is reached, the money doesn't come from the member's office budget, and it doesn't come from the member's pocket. It comes from a permanent, indefinite account at the United States Treasury, money already appropriated, standing ready year after year, requiring no new vote to release it. This account exists because of the Congressional Accountability Act of 1995, a law Congress wrote for itself, applying workplace protections that already covered every other federal employee to its own members for the first time. That sounds like reform. But buried inside it was a payment mechanism and a confidentiality requirement that meant every settlement could be closed out quietly, funded by the Treasury, without appearing in any budget line item anyone would recognize. No separate vote authorized each payment. No public hearing reviewed the terms. The same law that finally held Congress accountable also built the room where that accountability could be handled in private permanently by design. For 20 years, almost no one outside the Capitol knew the account existed. Then in 2017, during the wave of workplace misconduct reporting sweeping the country, journalists pulled the thread. What they found was that the Office of Compliance, the body that administers this fund, had paid out more than $17 million over roughly a decade, across 268 settlements, to resolve claims ranging from unpaid overtime to sexual harassment. The public didn't know which members were involved. Taxpayers had been funding it the entire time. Remember, no one voted for this. Not the payments, not the secrecy, not the decision to route it through a permanent Treasury account instead of a member's own budget. Here is what it means for an ordinary person working on Capitol Hill. If a staffer is harassed by a sitting member of Congress, and that staffer wants relief, they don't sue the way you or I would sue an employer. They file with the Office of Compliance, often under a non-disclosure agreement, and if money changes hands, it comes from this fund. Not from the member, not from campaign donors, not from the member's office account that voters can inspect. It comes from the General Treasury, the same pool that funds federal salaries and agency operations. The staffer signs away the right to speak publicly. The member's name is never entered into any record the public can search. The harassment happened, the payment happened, and by the time you finish reading this sentence, there is still no way for you to find out whose behavior it paid for, unless a reporter happens to go looking, the way one did in 2017. Congress did respond, eventually. In 2018, it passed a reform requiring members to personally reimburse the Treasury for settlements tied specifically to their own harassment. That sounds like accountability restored. But here is the part that should actually worry you. It's completely legal, and it barely closed the loophole. The reimbursement requirement applies narrowly, mostly to harassment claims initiated after the reform, and the underlying architecture, a private complaint process, a Treasury-funded settlement pool, confidentiality as a condition of resolution, was left standing untouched. Congress reformed the visible symptom and preserved the invisible structure underneath it. That structure can't be easily undone, because the body with the power to dismantle it is the same body that benefits from its existence. Any repeal has to pass through the chamber whose members are the ones being shielded. There's no outside regulator, no court with independent jurisdiction, no agency oversight. The Compliance Office reports to Congress itself. A law that governs the accountability of lawmakers is enforced by the lawmakers it governs, which means the fund only shrinks or grows by the will of the very people it protects. Think about what that means beyond this one fund. This is not a rogue office or a single corrupt actor. This is the ordinary, lawful operating procedure of the United States Congress, sitting in plain sight in the federal code for anyone who wanted to read it. If this mechanism was built quietly into a law that was supposed to be a landmark reform, designed to hold Congress to the same standard as everyone else, and instead engineered a private exit, then every other watchdog office, every other compliance body, every other agency you assume answers to someone, deserves the same question. Oversight that reports only to the people it's supposed to be overseeing isn't oversight. It's an appearance of oversight, wearing the name of a real one, and it was never hidden. It was simply never explained to you in language built for you to actually understand it, which raises the uncomfortable question underneath all of it. If the one institution writing the rules about its own misconduct also controls the ledger, the confidentiality, and the money, what does that tell you about every other office in Washington you assume is being watched by someone else?